I can't speak for across Europe. I can speak to some degree about the UK, and I think within the UK we do have a difficulty, a serious difficulty with accountability and scrutiny of the use of surveillance techniques. We have an overarching piece of legislation which has many difficulties that have been exposed in the 12 or 10 years it's been on the statute books. And we have a process of surveillance which is very hard to get underneath. Now, it's inevitable that there's going to be difficulties in scrutinising surveillance, but certainly in my country, in the jurisdiction I practice in, there is a real and urgent need to have a greater system of accountability and scrutiny of what are essentially intelligence gathering and surveillance of members of the public. I'm afraid the best answer I can give to that is maybe, and that's not very helpful. But the reason I say maybe is because I think it's too prescriptive to say it always will or it always won't. But what's critical is when you are examining the new technology and questioning whether you need a realignment, you have to ask yourself, why do we really need to realign? Is there something within the process that's faulty that requires a realignment? If there isn't, why are we doing so? And if we don't need to realign, do we still have confidence in the existing systems that we have? And I think those two questions should inform any debate about whether there's realignment. It's not wrong to ask the question, and the question will always arise when new technology comes up. But you have to always consider, why are you saying you might need to realign? And if you are doing so, how are you doing so without effectively losing some of the important protections that have taken years, decades, sometimes centuries to build up within each jurisdiction? I mean, I think all stakeholders within the framework, and that's politicians, members of the public, NGOs, judiciary, prosecutors and defence lawyers, everybody who has a part in that process has to understand not just that technology, but the consequences of that technology in terms of their human rights impact. And understanding one without understanding the other is really not being coherent and literate within that environment. I do think judges are receptive, but you have to look at what point you're asking the judge to intervene or somebody to intervene in that process. If you're talking about the use of that technology, assessing it once it's been used or in the context of a claim, then that's a different thing. Most judges, most prosecutors would probably think they can become aware of it as they need to, as they're dealing with that issue. But the problem is that it doesn't simply arise by assessing something after it's happened. It arises preemptively. Judiciary, prosecutors, they have to consider how the impact is going to be before they use it. And that's why, in my view, understanding the technology and its human rights implications is critical before you're faced with a decision, because if you don't understand it until after you've made the decision, that's too late.